Welcome to today's webinar, Legal Resources for Students and Young Adults Affected by Cancer. Just a little housekeeping before we get started. We will be recording today's webinar and sharing it on the CLRC, the Cancer Legal Resource Center's YouTube page. I will do my best to leave plenty of time for questions at the end of the workshop, and the question portion of this presentation will not be recorded. I will stop the recording and then I'll take time for questions. This presentation is supported by a generous grant from Seagen. I am an attorney, but today's presentation is not legal advice and does not establish an attorney-client relationship. So what is the CLRC? The CLRC is the Cancer Legal Resource Center. And our mission is to provide information and resources on cancer-related legal issues. And we are a program of the Disability Rights Legal Center based in Los Angeles, although we help people nationwide. And we have an educational model. We provide resources in Spanish, and we also have a language line. Everything is confidential. Hopefully, I will be able to answer the questions at the end of the webinar, but if I'm not sure, or if you have questions that come up down the road, this is the best way to get in touch with us, either filling out an intake on our website or calling our toll-free number to leave a message for someone to call you back to complete an intake. All of the information we provide is free, though we do not provide legal advice or direct representation. So, what are cancer-related legal issues? People often ask us, what does cancer have to do with the law? So, as you see on your screen, there's a list of some cancer-related legal issues. Cancer affects the patient, survivor, families, healthcare professionals, and impacts many different areas of the law. If someone has a legal question and is affected by cancer, whether or not the topic is listed here, they can contact the CLRC for more information. Now, if you are a lawyer or if you know a lawyer who may want to give back to the community, the CLRC has a professional panel, and this includes attorneys from across the country who help those with cancer if a caller needs help with a matter in their state and practice area. Now, you saw on the previous slide the practice areas that attorneys handle, but just to recap some of them: landlord-tenant, health insurance matters, medical malpractice, estate planning, employment law, and divorce law. It's a minimal commitment. All that the attorney agrees to is a half-hour consultation, and it is very easy to apply. The CLRC also maintains a library of fact sheets on a variety of cancer-related legal issues on our website, including a resource called our Patient Legal Handbook. The handbook provides a brief overview of many of the most common issues and questions that people living with cancer and their families have. And we'd like to give a special thanks to the handbook sponsors, the American Cancer Society and Breakaway from Cancer. If you're interested in receiving a large number of copies of our handbook, please submit a bulk order on our website. We also have PDFs of the handbook in English and Spanish available to download for free. So this presentation will cover a lot of ground, and towards the end of the presentation, I will be covering COVID-19 protections, but I wanted to lay the fundamental framework for information that will be available after COVID-19 pandemic protections go away, and what has been the landscape before and after those protections. So here is an overview of what today's webinar will cover. The Individual with Disabilities Education Act, IDEA, was originally enacted by Congress in 1975 to ensure that children with disabilities have the opportunity to receive a free, appropriate public education, just like other children. However, many of the protections that are available for younger students, such as free, appropriate public education or FAPE, and the Individuals with Disabilities Education Act, IDEA, do not apply to college level education. It is important that students with cancer related disabilities understand their rights and responsibilities when they are preparing for college level courses, and beyond. While there are many protections that exist for students of all ages, students have more responsibilities at the college or graduate level to request and assist in identifying the accommodations they need. The following information can help students with disabilities prepare for and succeed in college classes and beyond. And regardless of whether you took out student loans before or after your cancer diagnosis, paying back student loans can be challenging if your income is uncertain or you are in and out of the workforce. We will share some information in the last section of the webinar regarding student loan disability discharge and other options if you are having trouble paying back your student loans. There are a couple of laws that I will be discussing today. The first is Section 504 of the Rehabilitation Act of 1973, which is a federal law that offers certain protections for people with disabilities. The American with Disabilities Act, or ADA, also provides protections for people with disabilities in a number of different contexts. The picture that you're seeing on your screen is of the University of Utah in Salt Lake City, and it's an example of a public university that receives federal funding. So Section 504 is a federal law designed to protect the rights of individuals with disabilities in programs and activities, such as educational programs that receive federal financial assistance from the U.S. Department of Education. Recipients of this federal financial assistance include public school districts, institutions of higher education, private or public, vocational schools, and other state and local education agencies. If you'd like to know a little bit more of the language of Section 504, it says, no otherwise qualified individual with a disability in the United States shall solely by reason of his or her disability be excluded from the participation in, be denied the benefits of, or be subjected to discrimination under any program or activity receiving federal financial assistance. The American with Disabilities Act, or ADA, also prohibits discrimination against students with disabilities at the college level. Title II of the ADA covers state-funded schools such as universities, community college, and vocational schools. Title III of the ADA covers privately funded colleges, vocational schools, and private entities that offer certain educational exams and/or courses related to occupational certification. I mentioned that Section 504 applies to schools that receive federal financial assistance, which is the vast majority of schools. Private schools that do not receive government funds are only covered by Title III of the ADA. As a result, these institutions may be more limited in the types of accommodations they may be able to provide, depending on their available resources. Regardless of these limitations, however, they are still required to accommodate students with disabilities. What's the big difference between public and private? In a nutshell, the funding. Public schools get most of their funding from state governments, and private colleges receive theirs from private donations and tuition. Junior colleges, sometimes called community colleges, are government funded 2-year colleges that grant associate's degrees and certificates. Many students attend these schools for a year or two before heading off to a 4-year university to complete their degree. The photo that you see on your screen is of Harvard Law School, which is private. However, even most private schools these days do accept some forms of federal funding. So the fact that a school is private does not necessarily mean that Section 504 won't apply. Certain religious colleges, like Hillsdale College in Michigan, for example, have decided to forego all federal funding, including not accepting federal student loans. For these colleges, Section 504 may not apply. The ADA and Section 504 define disability the same way. Because these laws have a lot of complicated language, I want to first make sure we're all on the same page with the specific definitions. It's important to understand the law's definitions in order to know whether or not you are actually protected as a student. To be protected To be a protected person with a disability under the ADA or Section 504 of the Rehabilitation Act, there are three parts to the definition. You can see it on your screen and say it to yourself as I do. They have a impairment. That impairment limits a major life activity, and the limitation is substantial. Physical or mental impairment is pretty self-explanatory, so I won't go into detail about that. We talk so much about cancer's physical impairments, but as we know, there are a number of mental impairments that can also impact a person with cancer's ability to perform major life activities as well. So let's dive a little bit deeper. These are examples of major life activities. If you have an impairment that substantially limits one of these, you may be qualified as having a disability under ADA and or 504. So, a major life activity could be breathing, talking, walking, taking care of oneself, or working. Substantially limits means nearly impossible to perform the activity. So, let's go into a little bit more detail. They can include, when it comes to major life activities, and it's of course is not limited to this list: caring for oneself, performing manual tasks, seeing, hearing, eating, sleeping, walking, standing, lifting, bending, speaking, breathing, learning, reading, concentrating, thinking, communicating, and working. Now let's break down substantial limitation. Substantial limitation is an inability to perform a major life activity in the way that an average person in society would be able to perform it. The determination of whether a student has a physical or mental impairment that substantially limits a major life activity must be made on the basis of an individual inquiry. Note that this is not just the diagnosis or illness itself, but the side effects of treatment. For example, a treatment as a result of a cancer could have substantial effects and substantially limit the person's life activity. This requires a lower level of functional limitation than the standard previously applied by the courts. An impairment doesn't need to prevent or severely or significantly restrict a major life activity to be considered substantially limiting. Nonetheless, not every impairment will constitute a disability. The term substantially limits is to be construed broadly in favor of expansive coverage to the maximum extent permitted by the terms of the ADA. This is an individualized assessment. An impairment that is episodic or in remission is a disability if it would substantially limit a major life activity when active. Also, keep in mind that many schools will be willing to accommodate temporary disabilities, so it's possible that duration might not matter as much. The ADA and 504 do not only apply to people who currently have disabilities. So even if you had a disability in the past, for example, childhood cancer survivors or cancer that is now in remission, you may still be protected by these laws. A student may be protected from disability discrimination in higher education if he or she currently has an impairment that substantially limits a major life activity, has a history of that impairment. For example, if someone was diagnosed with cancer, has completed treatment, and is enrolling in a new school or class, the person is capable of completing the coursework, but the school or professor is treating you differently because of your history with cancer. He or she is regarded as having an impairment. For example, the school or professor knows of your diagnosis and starts to treat you differently, even though you are capable of going to school and don't have any impairment. Caregivers may be entitled to protection from discrimination based on association with the person with the disability. For example, caregivers of people with HIV or AIDS. So now that we know how the relevant laws define the term disability and who is protected by these laws, the next question is, so what? What are colleges, vocational schools, universities, and other higher education institutions required to do for students who have disabilities? These schools may be required to provide accommodations, also known as academic adjustments or auxiliary aids to students with disabilities. The next section will cover accommodations and where, when, and how to request them. Both ADA and 504 ensure that students with disabilities may not be denied admission to any school on the basis of their disability. A college or university may not use discriminatory methods to screen out or limit the number of students with disabilities that may apply or be admitted. Furthermore, the actual application cannot ask applicants if they have a disability. Once a student has been admitted, a school may ask whether a student has a disability on a confidential basis to determine if accommodations may be needed. Students are not required to disclose their disability if they do not require any accommodations. However, they must self-disclose in order to receive accommodations. Students may choose to discuss their needs privately with the Disability Services Coordinator or other similarly designated individual, rather than disclose their disability on a form they received from the school. Sometimes a student's disability may affect his or her transcripts or qualifications when applying to a college, grad school, or any other post-secondary school. If this situation applies to you, there may be a few options available. First, some schools allow for extra documents to be submitted with your application. These documents are sometimes referred to as addenda. An addendum, that's the singular version of addenda, gives you the opportunity to explain why a particular transcript or entrance exam may not be entirely reflective of you as a student or your academic capability. Some examples of when an addendum might be appropriate are an entrance exam score, GRE, LSAT, SAT, that does not accurately reflect your academic potential, or an exceptionally poor grade in a particular course, or a long gap in your previous school attendance, excluding summer, or taking time to complete a particular grade in high school. Second, you may consider talking about your disability and how it has affected your academic performance. For example, some students write their college personal statement about a life-changing experience, such as having cancer, and how that has affected their career goals. However, some students may not feel comfortable discussing their personal experiences, especially if they do not wish to tell their school they have a disability. The choice is up to you. If you currently have a disability and need some sort of accommodation in order to take an entrance exam or another similar exam, it's important to request an accommodation as early as possible. Under the ADA, what kinds of tests are covered? Exams administered by any private, state, or local government entity related to applications, licensing, certification, or credentialing for secondary or post-secondary education, professional or trade purposes are covered by the ADA. And testing accommodations pursuant to the ADA must be provided. So examples of covered exams include the high school equivalency exams, such as the GED, high school entrance exams, such as the SSAT or ISEE, college entrance exams, such as the SAT or ACT, exams for admissions to professional schools, such as the LSAT or MCAT, admissions exams for graduate schools, such as the GRE or GMAT, and licensing exams for trade purposes, such as cosmetology, or professional purposes, such as bar exams, medical licensing exams, including clinical assessments. Students with documented disabilities may apply for accommodations when they take College Board's exams, such as the PEACE, PSAT, NMSQT, SAT, SAT subject tests, or advanced placement exams. To be eligible for accommodations, a student must be able to document, first of all, the disability, second of all, the degree to which the disability impacts activities, also known as functional limitation, and number three, the need for the specific accommodations requested. All requests must be approved by the College Board Services for Students with Disabilities, regardless of whether a student receives accommodations at school. While there is a student eligibility paper form that families can fill out on their own, the College Board encourages students to work with their schools to request accommodations and testing for the following reasons. Online submission. Authorized educators at your school, called SSD coordinators, can use SSD Online to request accommodations. Online guidance. SSD Online walks SSD coordinators through the process of requesting accommodations, alerts them to what kind of documentation is required, and lets them know when documentation must be sent to the College Board for review. Streamlined process. While families using the paper form must always submit documentation to the College Board for review, SSD coordinators must only do so rarely. Convenience. When documentation has to be submitted to the College Board, SSD coordinators can submit it online. Experience. Your school's SSD coordinator has probably been through the College Board accommodations request process before with other students. Note, College Board approval for accommodations can take up to 7 weeks, and deadlines for accommodation requests may be earlier than regular exam registration deadlines. So, it's a good idea to request it early. Testing accommodations are changes to the regular testing environment and auxiliary aids and services that allow individuals with disabilities to demonstrate their true aptitude or achievement level on standardized exams or other high stakes tests. So, what testing accommodations must be provided? Testing entities must ensure that the test scores of individuals with disabilities accurately reflect the individual's aptitude or achievement level or whatever skill the exam or test is intended to measure. A testing entity must administer its exam so that it accurately reflects an individual's aptitude, achievement level, or skill that the exam purports to measure, rather than the individual's impairment, except where the impaired skill is one that the exam purports to measure. Examples of accommodations are listed on the slide, but this is not a complete list. An accommodation will be individually tailored to the person and their disability. Test accommodations may include, but are not limited to, extended time, extra breaks, private room, screens to block out distractions, specified time of day, or multiple day with or without extra time. Often, students with disabilities who need accommodations to make it possible for them to successfully take entrance and other educational exams will also need some support once they are accepted into the school and enroll in classes. So, how do the ADA and Section 504 protect higher education students once they're enrolled? Generally, just like the companies that are required to provide testing accommodations, colleges and universities are required to make reasonable accommodations to students with disabilities. These types of accommodations may also be called academic adjustments. These accommodations may include modifications in the school's practices, policies and procedures, or provision of auxiliary aids and services. An appropriate accommodation is determined through an interactive process based on the student's disability and individual needs. A school is not required to make any adjustments that would fundamentally alter the nature of a service, program activity, or would cause an undue financial or administrative burden. A school is not required to waive or lower essential requirements, nor required to provide accommodations to students who do not disclose that they have a disability. Once it has been determined that you are a qualified individual with a disability under the ADA, you are entitled to request a reasonable accommodation from your school. A reasonable accommodation is any change or adjustment at school in the way that things are customarily done that enables an individual with a disability to enjoy equal education opportunities. Now, keep in mind that these requests do have to be reasonable. You cannot ask for an accommodation that would completely change the nature of the class or what you would be learning or evaluated on. For example, we spoke with a caller once who was struggling to make it to her college chemistry class due to her ongoing medical condition and last minute doctor appointments. Unfortunately, the class had a significant lab component, and attendance at the lab sessions were mandatory. Although she attended all but one of the lab sessions, her professor failed her and refused to let her make up the one lab session she missed, and instead insisted that she repeat the entire class. In this case, it might not have been reasonable to ask the professor to waive the lab component altogether, especially if it was integral to the class. But perhaps the professor could have done something else to accommodate her needs instead of simply demanding the entire class be repeated. Making up the lab session, attending the session during a different semester to make it up, and therefore finishing an incomplete instead of a failure might have been an alternative option, or possibly assigning other alternative work that could be done from home. We've also spoken to students with other attendance issues where the professors were able to accommodate with some of the above options, or by simply adjusting the attendance policy for that particular student. What are some types of reasonable accommodations that a person with cancer might need? Some examples are extra time on exams, note taker services, access to adaptive technology, a screen reader, for example, or additional excused absences. Now, I know I'm covering a lot of ground, and the great thing is that this presentation is recorded, so you can go back and watch it and even go to a specific part of the presentation and pause it there. You can take down notes. You don't have to take down notes right now. You can, of course, but all this information will be available later. So, all school programs, including extracurricular activities, must be accessible to students with disabilities. Further, if a college offers housing, it must provide convenient and accessible housing to students with disabilities who need it. The housing must be provided at the same cost as it is for other students and must be comparable to the housing provided to other students. A school may not charge a student for accommodations that he or she needs. A school may also not charge its students with disabilities more tuition or program costs than it does for other students. If you've been accepted into a college or graduate program and you have a disability that needs accommodation, you might be wondering how to go about requesting the accommodation. Most post-secondary educational institutions have an office or designated individual, such as a disability services coordinator or access coordinator, responsible for coordinating accommodations for students with disabilities. Students can obtain information about the school's procedures for requesting accommodations through this office or individual. If you are uncertain about who is responsible for coordinating accommodations, try searching the school's website for disabilities services. This information may be listed under health services, learning accommodations, student resources, or student services. If the school's website does not contain information for students with disabilities, try contacting the Dean of Academic Services, Dean of Student Services, or Admissions Office to find out who's responsible for ADA accommodations. While you will need to disclose your disability after you are admitted in order to receive accommodations, you can exercise control over when and to whom to disclose this information. The Disability Services Office or coordination must keep information about your disability confidential and may not discuss your disability, except on a need-to-know basis to provide appropriate accommodations or emergency planning and response. Information about your disability does not go to your school to go onto your school transcript or record. It is important to request an accommodation as soon as you know you might need one. This will enable you and the school to plan accordingly. Some accommodations may require more time to arrange, and it is generally more costly and more difficult for a school to secure accommodations on short notice. Waiting too long to ask for an accommodation might also mean that your disability affects your performance on a test or project, and poor performance could ultimately result in your receiving a poor grade or having to repeat a class. If the need for an accommodation arises unexpectedly once you have started a program, or if your need for accommodation changes, contact your school's services office or coordination as soon as possible. So, when should you request an academic adjustment? Although you may request an academic adjustment from your post secondary school at any time, you should request it as early as possible. Some academic adjustments may take more time to provide than others. You should follow your school's procedures to ensure that the school has enough time to review your request and to provide an appropriate academic adjustment. For example, we've spoken with students over the years who were hesitant to talk to professors or teaching assistants about the potential need for extra time or additional excused absences, which did lead several of them to fail a class, needing to repeat it or getting an incomplete, such as the student in the previous example who failed her chemistry class for missing one lab session. It's been our experience that some professors are much less willing to make accommodations for students after their performance in class has suffered. Accommodations are determined through an interactive process, essentially a negotiation. So it is helpful to think about what types of accommodations might suit you best and put your request in writing. Try to be as specific as possible so all your concerns can be addressed properly with an accommodation or modification. In addition, the request should describe how your disability affects your participation in school, functional limitation, and how your recommended accommodations can help you. Schools may also differ in the documentation they require to show the need for a reasonable accommodation. Check to see what types of documentation your school requires and have it ready to submit with your accommodation request. For example, a signed letter from your treating physician that verifies your disability and functional limitations and suggests accommodations. So, what if your accommodation request is denied? Try contacting the Dean of Academic Services, Dean of Student Services, or Admissions Office to find out who is responsible. If your school denies requests for accommodations or you're dissatisfied with the accommodation you receive, you may have access to an appeals process for reconsideration. If you've tried to speak to a professor directly about an accommodation and he or she has denied it, make sure you talk to whoever's in charge of ADA accommodations at your school. And if you've only spoken to the ADA coordinator and not your professors, try speaking with your professors directly. Some may be more accommodating than you anticipate. All government funded schools must have a grievance procedure for addressing discrimination complaints. If your situation cannot be resolved informally or by discussing the matter with the Disability Services Coordinator or point person responsible for ensuring Section 504 and or ADA compliance, you can follow your school's grievance procedures. One example of a school resource that would explain this information would be your school's student handbook, or you might find this information on your school's website. If you're unhappy with the result of your school's grievance procedures or want to pursue an alternative to those procedures, you may file a complaint against your school with the Department of Education by contacting the Office for Civil Rights. Note that you only have 180 days following the date of a discriminatory action to file your complaint. To receive more information about the civil rights of students with disabilities for school purposes, you may contact, and there you see it on your screen, the U.S. Department of Education Office of Civil Rights. And for more information about the ADA and Section 504 of the Rehabilitation Act, please contact the U.S. Department of Justice. Now, as I mentioned, we're the Cancer Legal Resource Center, so we provide resources. But again, you don't have to jot this down if you don't want to. You can access this information later when we post the recording. Part 3. Student loans. So student loans account for more than $1 trillion of debt in America. While some students need to take out loans in order to afford college, education-related debt can often take a long time to pay off and requires careful planning. It's often difficult enough to pay back student loans. An unexpected cancer diagnosis could make it even more difficult to repay some of these loans, but there is a program that may be able to help. If you're facing a situation where you think you might not be able to pay your loans, or if you are already falling behind on your payments, there are a few different options you can look into. While I won't be discussing all of the different types of loan repayment plans, it is important to talk to your loan servicer if you're struggling to make payments. It's possible that you may qualify for an alternative repayment plan or schedule, and there are repayment plans based on your income. Keep in mind, you might be able to get a deferment or a forbearance, regardless of what types of loans you have, federal or private. I will go through each of these options in detail over the next few slides. If you're facing a temporary loss of wages or funds, you might be able to you might want to consider requesting a deferment. A deferment is a period during which repayment of your principal balance of your loan is temporarily delayed. During deferment, you do not need to make payments. What's more, depending on the type of loan you have, the federal government may pay the interest on your loans. The government may pay the interest on your federal Perkins loan, direct subsidized loan, and or subsidized federal Stafford loan. The government does not pay the interest on your unsubsidized loans or any PLUS loans. You're responsible for paying the interest that accrues or accumulates during the deferment period, but your payment is not due during the deferment period. If you don't pay the interest on your loan during deferment, it may be capitalized or added to your principal balance, and the amount you pay in the future will be higher. Some accepted reasons for deferment of repayment include inability to find work, period of economic hardship, or period of active military duty. To request a deferment, please contact your loan servicer. Your loan servicer is the one that will make the decision as to whether or not to grant you a deferment, and there might be limits on how many deferments you can request. For example, students are often granted deferments while they're in school, and there is often a 6-month grace period after graduation before loans go into repayment. So let's go over forbearance. If you can't make your scheduled loan payments but don't qualify for deferment, your loan servicer may be able to grant you a forbearance. With forbearance, you may be able to stop making payments or reduce your monthly payment for up to 12 months. Interest will continue to accrue on your subsidized and unsubsidized loans, including all PLUS loans. To request a forbearance, please contact your loan servicer. So there's something called a discretionary forbearance. That's where your lender decides whether to grant forbearance or not. You can request discretionary forbearance for financial hardship or illness. Mandatory forbearance. If you meet the eligibility criteria for your forbearance, your lender is required to grant the forbearance. So, for example, you're serving in a medical or dental internship or residency program and you meet specific requirements. The total amount you owe each month for all the student loans you received is 20% or more of your total monthly gross income. Additional conditions apply. You are serving in a national service position for which you received a National Service Award. You are performing teaching service that will qualify for teacher loan forgiveness. You qualify for partial repayment of your loans under the U.S. Department of Defense Student Loan Repayment Program. You're a member of the National Guard and have been activated by governor, but you are not eligible for a military deferment. If you borrowed certain types of federal loans to attend college or graduate school and you have a total and permanent disability, or you may qualify to have your loans forgiven or discharged so you don't have to pay them back. The federal government has a program called Total and Permanent Disability Discharge, TPD, and it applies to only very specific type of loans. William D. Ford Federal Direct Loans, or also called direct loans, Federal Family Education Loans, FFEL, and or Federal Perkins Loans, or Perkins Loans. The program also applies to individuals who have to complete a grant service obligation. The TPT discharge only applies to federal loans that you borrowed for college. Reminder, TPD stands for Total and Permanent Disability Discharge. So a TPD discharge relieves you from having to repay a William D. Ford Federal Direct Loan and program loan, Federal Family Education Loan, FFVL program loan, and a Federal Perkins Loan on the basis of your total and permanent disability. So private student loans borrowed from a bank or other financial institution are not eligible for a TPD discharge program. Private loans are not subsidized or regulated by the federal government and do not have the same types of discharge, deferment, or forbearance options that are available for federal loans. If you're unable to pay a private loan, it is best to contact the private lender and find out if you can negotiate some of the debt or come up with an alternative payment plan. If you're watching this webinar in anticipation of going to college or graduate school and you're trying to learn more about student loans, please keep this in mind. Private loans often have high interest rates and are not regulated the same way as federal loans. Before these loans can be discharged, you must fill out an application and provide information to the U.S. Department of Education to show that you are totally and permanently disabled. There are different ways you can show that you are totally and permanently disabled. It will depend on whether you're a veteran, receiving Social Security benefits such as SSDI or SSI, or if you have a long-term disability that prevents you from working. For specifics on how to show your disability, visit the TP Discharge website at www.disabilitydischarge.com and click on Application Process to see what else is required. You can also contact the NELNET Total and Permanent Disability Servicer at 888-303-7818. Depending on your situation, you'll have to provide evidence about your Veterans Affairs disability, evidence about your SSI or SSDI determination, or you'll have to provide a physician certification that shows you have a disability that has lasted at least 60 continuous months and is expected to last for another 60 months or 5 years or end in death. If your TPD discharge request is approved, you will be notified by NowNet. Any loan payments you made on or after you became totally and permanently disabled will be returned to you, and your loans will then be discharged. Depending on how you showed your disability, you may also be subject to a 3-year monitoring period that begins from your TPD discharge date. If this applies to you, you will have to meet certain requirements to keep your loans discharged. If the 3-year monitoring period applies to you, your loans will be discharged for the first 3 years after your TPD discharge. You do not have to make any payments towards your loans for these 3 years. However, you may have to begin repaying your loans again or fulfill your Teach Grant service obligation if during the 3-year monitoring period your yearly employment income exceeds the federal poverty guideline amount for a family of 2 in your state, regardless of family size. You receive a direct loan, Perkins loan, or Teach Grant. You received a direct loan, Perkins loan, or Teach Grant before your TPD discharge date, and you do not return the entire amount of the loan within 120 days of the date you received it, or your disability status changes for purposes of any SSDI or SSI benefits you are receiving. Because of a change in federal law related to the taxability of loan amounts, discharge due to TPD? The answer depends on when you received the discharge. If you received a TPD discharge of a loan before January 1st, 2018, the loan amount discharged may be considered income for federal tax purposes under Internal Revenue Service IRS rules. If you received a TPD discharge of a loan during the period from January 1st, 2018 to December 31st, 2025, the discharged loan amount won't be considered income for federal tax purposes. For purposes of determining whether a loan amount discharged due to TPD may be treated as taxable income for federal tax purposes, the date you are considered to have received the discharge is different depending on how you qualified for the discharge. If you're a veteran who showed that you're totally and permanently disabled based on a disability determination by the VA, you're considered to have received the discharge for federal tax purposes on the date we approved the discharge. If you're showed that you're totally and permanently disabled based on documentation from the SSA or physician certification, meaning that you're subject to a 3-year post-discharge monitoring period, you're considered to have received a discharge for federal tax purposes at the end of the post-discharge monitoring period. For example, if your discharge was approved in July 2017, you would not be considered to have received the discharge for federal tax purposes until July 2020 at the end of the 3-year post-discharge monitoring period. Therefore, the IRS would not consider the discharged loan amount to be taxable income for federal tax purposes. Loan amounts discharged due to TPD may still be considered income for tax purposes. If you receive a TPD discharge of a federal student loan, you may want to consult with your state tax office or tax professional before you file your state tax return. Now, let's get to COVID-19 related protections. You may have seen this on the news, and as of the date of this recording, we've been updating this presentation to encompass the latest in national news. So, the CARES Act that was signed in March 2020, it provides the following student loan relief. You can see it on your screen: suspension of loan payments, interest does not accrue on loans, no collections of loan defaults. The original end date was last September, but has since been extended multiple times. So if you've seen different deadlines based on different articles or news, in August, the U.S. Department of Education announced a final extension of the student loan payment pause until January 31st, 2022. So as of the date of this recording, next January, that until then, the Department of Education announced a final extension of the student loan payment pause. So that is the latest as of the date of this recording. Now let's take a little bit closer of a look of the types of loans. I won't go over all of them because it's on your screen. You'll be able to see it and see if your particular loan qualifies. Not every loan does. As you can see, there are several that do and are eligible. I'm going to pause for a moment in case you want to jot it down quickly. And certain ones do not qualify. They are ineligible. ED, by the way, is the Education Department. And looking further at COVID-19 and student loans, so the CARES Act Higher Education Emergency Relief Fund, it covers expenses due to campus disruption secondary to COVID-19. The students can apply for grants to cover eligible expenses such as food, housing, course materials, technology, healthcare, and childcare. Now, again, this includes not just people who are affected by cancer, but I wanted to make sure that if someone is affected by cancer, they can know all the possible protections. It's a one-stop shop of information that could be helpful. Now, the school has complete control as to those eligible for grants, how and when they are distributed, and the grant amount. And again, since we are the Cancer Legal Resource Center, of course, the presentation as we conclude has to provide resources. So here are some agencies or places that may be helpful for you and their contact information. I'll pause a moment for you to take it down. And now we have reached the end of our presentation. Thank you so much for your time and going on this journey of learning more about legal resources for students and young adults affected by cancer. If you have general questions about today's presentation or need some clarification, I will stop the recording in just a moment and take time for questions. And again, if you have questions about your specific legal matter as it relates to cancer, please call our intake line or fill out an online intake. That information is on your screen so we can take a look at your issue and provide you with specific resources and customized solutions and referrals. It can be about this presentation or a completely different topic related to your cancer diagnosis. Whatever it is, we will help you, and we never charge. So wherever you are in the United States, please contact us if you have specific questions. And again, now I'm going to stop the recording.